Teresa Phillips. I'm coming from Forster Bowman. I'm an attorney that practices there. If you've joined us before, as I always start these things out, I like to remind everyone my primary area of practice is in fiduciary disputes, including guardianships, probate, and trust disputes, and that sort of litigation and adversarial matters. What we have coming to you today is actually a part two of a two-part series. And it discusses the weaponization of Florida guardianships. That's a term I coined to kind of describe this phenomenon wherein guardianships, not just in Florida, but somewhat all over the country, are starting to become more prevalent in the news. We're hearing more stories where sort of guardianship's gone wrong. So this two-part series has been trying to delve into the guardianship code and the issues and all those things surrounding guardianship here in Florida in an effort to identify the issues, identify how the issues come up, and sort of get a better understanding of what we can do to prevent a bad guardianship or finding our clients on the wrong end of a guardianship. Sit back, enjoy, and as always, please send any questions you have. I'll try to address them as we're going through the webinar materials, if not, certainly at the end. And now I'm gonna cut off my webcam so you guys can concentrate on the slides. So let's look at our agenda for today. We're going to start in section 1 here, and we're going to look at the current status and trends in Florida guardianship law. We'll start out by recapping part 1. In part 1 of this series, we concentrated on delving into the nuts and bolts of the guardianship process and understanding how it works and trying to understand all the steps in the process. We'll also look at the new proposed legislation related to the guardianship code and try to figure out why it may fall short of the mark and what's been identified as sometimes shortcomings in guardianship matters. In section 2, kind of ask that question about trying to figure out when someone's helpful or not so helpful. I'll call it predator or prey. As we kind of delved in section 1 of this seminar, the guardianship code sort of presumes everybody's acting in good faith and the allegations made are in good faith, and when they're not, or when they're manipulated, or certain key facts are left out, the key players in the guardianship may make poor decisions based on that. So in this section, we'll look a little closer and recap who are those key players in guardianships matters, who is driving the actions, who is there to protect, who's there to oversee, that sort of thing. And then we'll look at some signs we've identified that could show you if your client or you yourself may one day be a victim of an unscrupulous relative or caregiver who may try to use guardianship in an unscrupulous manner. Section 3, we're going to try to get into some preventive measures today. We're going to look at from what everybody seems to think is the go-to preventive measure to, or to having some kind of control over whether or not you end up in a guardianship you don't want to end up in. One is the pre-need guardianship designation statute, which allows for people to ahead of time pick whom they would like to designate as their guardian before they're in any kind of incapacity proceeding. And then we'll look at how estate planning and trust are often used as at least what people think might keep them out of guardianships. And then we'll delve a little bit closer into how to protect those assets, and maybe if the real goal is to kind of keep them out of a guardianship court or keeping someone to gain control through a guardianship order, maybe some other protective measures you might want to take. Finally, or nearly finally, we'll look at the pop culture phenomenon that guardianships have become. I put here the Free Britney and other nightmare scenarios. The Free Britney movement refers to Britney Spears. It became kind of sort of a phenomenon, #Free Britney last year, in light of her conservatorship that she's been under, which is in California is very similar to a guardianship. And she's been under that apparently for over 12 years, almost 13, and wants out of it. So that gains some notoriety because of who she is. We also have seen this become a subject in movies and documentaries, and both fiction and nonfiction. So so let's look at what is it about this that that has some entertainment value and has people's attention, and how that's bringing attention to the whole concept of guardianship. I would dare to say a couple years ago, very few people would even have known what conservatorship or guardianship was really referring to. And then finally, as always in our webinars, we'll end with a conclusion and question and answer session. And again, I encourage you to pose any questions you have. We're always happy to answer those. So with that, let's delve in. Section 1, the current status and trends in Florida guardianship. What's going on with the law here? Let's recap a little bit of what we looked at in the first part of our webinar. And that one, we really delved into the code. How do you get a guardianship? How what are the things that the criteria that's involved? What are the protections in place for the ward or the alleged incapacitated person? How do how does it end up that you may end up with a guardianship that you may not want? If you may remember, we looked at the policies behind the legislation, and there was a emphasis on courts employing the least restrictive means possible to allow the ward to have some control over their life whenever possible and not to harm them, all those kind of things. But then we looked into the statute itself, and we saw that that despite all this, you can still end up with a guardian that maybe you do not want, or that you emphatically have stated you do not want. So I've kind of created this chart to kind of summarize in just short order. How do you end up with a guardian in Florida? Well, obviously it starts out with someone alleging an incapacity, and whether it be because of a mental or physical infirmity that somehow keeps you from doing the daily functions of life, that can contribute to some kind of harm to either your person or your finances. And remember, we looked at there can be a guardian of the person, there can be a guardian of the property, or there can be a guardian of both. So you start out, is the person incapacitated? If no, then no guardian. End of story. If yes, we look at then the court's required to look at the least restrictive means that adequately meets the needs. Now, in this situation, has there been some pre-planning? Are the assets in a trust where a trustee is controlling them, and the trustees, there's no reason to believe that they're not trustworthy? Are there some other means? Is there, a durable power of attorney whereby somebody can make decisions, healthcare surrogate, they can make decisions, and maybe it's a spouse or someone that the court deems responsible enough and trustworthy enough that the court doesn't need to stay involved and do further monitoring of the situation. Those are the questions that the judge has to look at and determine if there's anything short of a guardianship that will protect whatever it is this particular incapacitated person's in need of. And that's going to be very circumstantial, and a lot of it's going to depend on if you did some pre-planning and have some processes in place that may handle your needs if you become incapacitated. So if there is a less restrictive means that adequately meets the needs of the ward, the court is supposed to end there. The court's supposed to release jurisdiction and allow those means to go to further to handle the needs of the incapacitated person after making such findings. But what about no? What if the court says, well, maybe you have a durable power of attorney, but the person that is the attorney in fact is someone that's been accused and maybe found to be exploiting you, have been taking funds and things. So even though you have it, it's not adequate. Then the court's going to have to look at a guardianship. So the first thing the court should look at to see, is there a pre-guardian designation? That's a form, and we'll look a little bit more detail later on, that you file for record before you become incapacitated, if you so choose, and you can designate who your guardian should be if there's ever a need for one, and you can name a successor and things like that. If someone's named, usually the court will look to see if the designee is qualified under the statute. To be qualified under the statute, it's pretty simple. You can't have a criminal history of felonies or crimes involving abuse or exploitation. And of course, you have to be 18 years old and competent. Sometimes people believe you have to be a resident of the state. That's not necessarily true. Only, it's not a disqualifying event if you're not. It may be something the court takes into consideration as a practical consideration, but it's not a disqualifying event. So is the designee qualified under the statute? No. Well, then the court's got to find someone else willing and able to serve. If they are, that should be the stopping point, unless the court has some other reason not to trust this person. Like the durable power of attorney example, maybe this person's been involved in some exploitation of the person, financial exploitation, or some other event that calls into question whether they should serve as guardian. Maybe they're not qualified by statute, but maybe in the court's mind, they wouldn't be the best person to serve. So if not, if the designee guardian is qualified but are not qualified or otherwise can't serve, the court has to look to see if there's a family member that may be willing and able and qualified to serve, and has to decide whether a family member or close friend, an individual should serve, or if not, if there's no one there that's either willing or able or adequate to do that, then the court will in all likelihood appoint a professional or a public guardian. A public guardian's essentially a professional guardian that's paid by the state when the person doesn't have the financial means to pay for a professional guardian. So that's a very short track of saying, how did it go from one day I'm sitting here having maybe some memory problems to all of a sudden I have a guardian. That's a very simplified way of saying how the court and the analysis should have happened to end up with whether or not you have a guardian and who the person is that is serving as your guardian. So let's look at some new proposed legislation and why it may fall short of the mark. There is a bill or proposed law that's floating around. It was endorsed by a lot of influential groups, including the reptile group of Florida attorneys. And its main goal, as stated, is to modernize the statute and to bring some uniformity to it. That's what you primarily hear when you see the commentary on it. Here's some key points about it. The newest proposed changes in laws affecting the elderly community and intended to protect from exploitation, both physical and financial, are primarily in the field of guardianship. Florida is looking at guardianship to try to fix some of these issues. It has not made it, the bill has not made it, or the proposal hasn't made it past being a proposed bill, but is definitely being supported through lobbying efforts and expected to get through this legislative session. Florida guardianship law provides for the appointment of a guardian of an elderly person when the person is deemed to be incapacitated, at least in part. Actually, that's, it's guardian of any person that's deemed to be incapacitated, at least in part. And as we've seen before, the guardian can be limited or plenary, and the guardian can be of the person of the property. Nothing like that is changing in the new proposal. However, after noting there hasn't been a comprehensive rewrite of Florida guardianship law since 1990, this has kind of left a hodgepodge of additions and revisions to the law, and the new proposal means to streamline that. And I think they're even proposing a whole new chapter and to help the courts be more uniform. Some of the things that are missing in there, some of the specifics has left different counties and different circuits handling things differently. That can be from what kind of background check they do to what the procedures are about setting a hearing and the deadlines and things like that. There are some differences in how the circuits and counties are actually going through the guardianship process and bringing them to a hearing. And I think in good part, this new legislation that's being proposed recognizes there should be probably some more uniformity to that. It should be the same in Broward County as it is in Duval County, so to speak. So what's the goals of the rewrite? To bring uniformity and clarification to many of the statutes, and to take some of that ad hoc piecemeal legislation that we've been experiencing for 30 years and put it into one workable kind of chapter. It does have an emphasis on due process for the wards. It tries to firm up some of the deadlines and things of that sort. If anybody's ever been involved in the guardianship process, you'll know that sometimes, examining committee members don't get reports back timely, things like that. And sometimes the hearing keeps being delayed and keeps being delayed, obviously to the detriment of a alleged incapacitated person. So a lot of the statute is meant to firm up what the deadlines and things like that should be. Probably one of the most significant parts of the proposed legislation is it does work to protect the ward's privacy, and it enhances the confidentiality of the process. Much more of the filings and the information is kept confidential than it already is. Now that's a double-edged sword. Some people say, well, without knowing what, without third parties knowing what the guardian is doing, essentially, for example, if now a petition to, to sell property or a petition to do something with a ward, move the ward and things of that sort, if that's not known to other parties, who's going to be able to raise that issue or note that there's something wrong to the court if it's not been brought to the court's attention. So while that's good that maybe more things are being kept confidential, it may be kept confidential from people who might be actually interested and have some interest in advocating the ward's position, such as family members and things of that sort. I would say even the press at this point, since these kind of stories, even local Central Florida cases have become the subject of many articles in the newspaper asking questions about why was this allowed to happen? Why did the judge allow this? Why did the guardian do this? This will definitely probably put a lot of stop, or at least some obstacles to journalists finding out more about what's going on in these guardianship matters they're reporting on. The statute seeks to establish more comprehensive procedures for determining alternatives to guardianship. There's criteria in there that the more specific that the court's going to have to consider, so that that's not just a throwaway consideration for the courts. They try to make it easier for a professional guardian to resign when they're no longer willing to serve. Again, some people say that might not be great because now a professional guardian can just, under this proposed legislation, at least the professional guardian will be able to resign at will. Court will have to accept it. If the ward runs out of money, the guardian can just very simply resign, but very little opposition or steps to take under this new statute. Some would say that gives the professional guardian a way to get out without answering a tough question, maybe from the judge, as to what happened to all the money and why do you need to, all of a sudden do you need to resign. Finally, it's designed to prevent granny napping. That's generally a term where people will move people or isolate people to try to keep control over them. So there's more provisions about not being able to move the ward as easily and maybe not being able to isolate them from other people. So what's missing? Well, this is probably more my opinion, depending on whether it's needed, but it's definitely probably missing. It's probably fair to say it's missing, and in my opinion, probably needed. There's not more encouraged oversight over professional guardians. I was surprised to see that. I thought, especially with the Rebecca Fearley issue coming to light, where the professional guardian, was allowed to run amok for quite a while until some of her shenanigans were discovered by a local judge, Judge Thorpe, and that sort of got the ball rolling on unraveling what she had done, which at least allegedly led to the death of someone, a ward under her care. When you see things like that, when you hear the horror stories of professional guardians that were allowed to do a lot because they just either through lack of oversight or maybe misrepresentations by the guardians that didn't bring up the appropriate red flags, they were able to get away with a lot of bad conduct, a lot of harmful conduct for a long period of time. So I was surprised there's nothing in here about some procedures, some more specific requirements of judges, clerks, other people involved having to oversee the professional guardians a little bit more closely. And there's no additional consequences for lack of oversight and proper management. Again, that kind of goes with the first one. To encourage oversight, one of the ways you could do that is to have more negative consequences. Removing someone, if you get caught, maybe there should be more. And then more accountability for key players I was hoping for. As we looked into the part one of this webinar, for example, when someone petitions for incapacity for someone and they don't have a good faith belief, they're using it to gain leverage or using it to intimidate the person. There's that can cause a lot of harm, cause a lot of waste of assets, and one that person can eventually be, held accountable for the attorney's fees and costs that's been incurred if they're found to have acted in bad faith. That's not really the most dissuasive kind of argument to keep people from doing this. Maybe the benefits outweigh the cost of doing that if there's a finding they acted in bad faith. But I'd like to see more accountability for other people, people involved, including the professionals that are in charge of the ward or the alleged incapacitated person, fulfilling their duties, and when they're negligent in those or they don't do those correctly, I would like to see there would be more accountability for that. But there's nothing like that in this proposed legislation. If you want to see the full summary, I've given you a link there. And even if you just Google, RPPTL, new guardianship legislation, you'll probably find a good summary of it. And you can make a decision for yourself on how adequate you think it is. So let's move on to section 2. I call this one predator or prey. This is going to follow up to what we looked at in part 1, where you look at the players in a guardianship and understanding that the guardianship code presumes everybody's going to play their role in good faith and without nefarious, motivations and things of that sort. It typically works out well. But when any of the key players maybe fall short of what they should be doing, or intentionally have bad intentions, it can go from just simple negligence, simple oversight to having outright bad motives. Any of those things happen, guardianship is more likely to become a nightmare and not achieve the goal of actually helping the ward more than it hurts. So just so that as we're going through this, so you can remember all the potential players involved, I've kind of listed how the ones that you're more than likely going to see in any given guardianship. There's going to be the petitioner, the person who initiated all this, the person who brought these allegations before the court and essentially put the person in a role of being forced to be examined, being forced to go through a process and things of that sort. So they play an important role. The allegations they make in that petition control how things are going to be handled in a lot of ways. If they allege things that look like an emergency situation, that there might be imminent harm, either to the person or the property, you may see an emergency guardian appointed right away who can control certain aspects of the person's life, and that's without even someone examining them before any kind of determination is made. So the petitioner that's involved and their motives certainly can play a key role in this. The next of kin, can be important, especially as someone who maybe serves as another oversight. A lot of times when these folks are brought before on an incapacity petition, a lot of times it's because they are isolated and they don't have family members who are looking in on them and taking care of them. So a lot of times you're missing that next of kin, the brother or the daughter, or someone who's going to keep an eye on things and make sure that the petitioner's not misrepresenting things or leaving things out that are key, and making sure that the guardian is someone that their loved one is comfortable with, and maybe even serving as guardian themselves if the need be. So whether there's next of kin or not can change the dynamics of how a guardianship is handled. Whether there's a pre-need guardian, if you've designated one, that person can be a key player. They can be one of the most important key players if they're willing to be involved. Sometimes you find people that you put down your sibling or another loved one, or maybe even a good friend that you trust down as your designee. But then after someone files a petition, the kids are, are fighting over, whether, their father is incapacitated or not. Maybe that good friend or that uncle doesn't want to get involved and doesn't want to be put in the position of making his friend or his brother or loved one become an enemy of them by becoming a guardian when they clearly don't want a guardian. And then there's already maybe some disagreement among other family members. So sometimes you need to remember the pre-need guardian, even though they're a preference, they have to they have to want to be involved, and sometimes they don't want to. And if they don't, then that's going to make a little bit more open up a vacuum as to who's supposed to serve. And so they're an important player for all those reasons. The caregiver, the facility where maybe this person who's subject to the petition is living or under their care, they can play a big role. They can make allegations or not make allegations that can be helpful or not helpful to the incapacitated person or the petitioner. They're oftentimes the people or the persons who have the most knowledge of day-to-day events surrounding the alleged incapacitated person. They also will have sometimes an interest in the proceedings, especially if they're interested in having a guardian who will pay for their continue to pay for their care. Is there an attorney in fact? Someone's been named in a durable power of attorney, or is there a healthcare surrogate designee that's involved? They can be important for two reasons. One, they may be the source of not needing a guardianship. Maybe they're the lesser restrictive means, but they have to be willing to serve in those capacities. They have to continue to be willing to continue to serve, and they have to be someone who maybe hasn't gotten themselves in a position where their credibility has been called into question. For example, if the whole reason the petition was filed was because the attorney in fact was writing checks to themselves and doing things that were exploiting the petitioner or the alleged incapacitated person. So who's in, whether there's certain people named, what kind of relationship they have, and their willingness to serve will play a key role in how the guardianship plays out. There's the judge. As we've seen from the articles, judges first of all, they have the key oversight power. I mean, the statute's kind of structured so that the judge is essentially the gatekeeper, and depending on how much oversight and how much attention and how many questions are asked, judge can have a key role in how a guardianship plays out. We saw that when with the Rebecca Fearley case, when Judge Thorpe started asking some questions that hadn't been asked before because there hadn't been enough red flags raised, and completely changed the dynamic of not just that guardianship but hundreds of others. Again, they're intended to be the key gatekeeper, so their involvement is key to how a guardianship will play out. The guardian themselves, how their relationship is not with their ward, how much trust the ward has in them, and the decisions they make will control a lot of how the guardianship plays out. Whether the guardian, what their long-term plans are, if they think the ward should be living in a facility, if the goal is to keep them in their home as long as possible, all those things, the guardian's decisions on those are going to be given a lot of weight and usually be supported by the court. So their relationship and their understanding of what the needs are of the ward will play a key role. Obviously, their diligence in their role will play a key role as well. If they're not diligent in keeping up with the needs of the ward and how they may change, obviously the whether the guardianship will be successful will depend a lot on that. You also have a court-appointed attorney, and that person's overlooked sometimes. They're the person that the court appoints in the beginning when there's a petition filed. They're called an advisor, and then their first role is to go out and read the petition and the notice to the alleged incapacitated person and do the best to make sure they understand what's going on. And that can be easy to hard depending on the faculties of the person they're dealing with and trying to explain to them what's going on. And then they have an enviable task of representing someone who may or may not be incapacitated. So their ability to communicate, understand, and and able to and communicate back the desires of the ward or the alleged incapacitated person is important too. And so I list this out so to kind of make it clear who we're usually seeing playing out in these scenarios. And as we've gone through these, I think it's become clear that these people can have their own motivations, they can have their own biases, their own preferences of what happens in the case, and they all have, they can all play a key role in decisions that are going to affect this one person. And I think when you see that, you can see where if any of these folks are acting in bad faith, negligent, um, with an unscrupulous, conflict, unscrupulous purpose, conflict of interest, where their own interests are paramount, you could see where things could go awry. So now let's look at some signs that you or your client may one day be a victim of an unscrupulous relative or caregiver. Those key players we looked at. What if you have a relative who has been who is not, let's say it's a child who has a sibling and they don't like the sibling and they'd like to see the sibling cut out. And maybe they'd like to get control of their father's, assets because the father maybe has been very generous with this sibling, and they want to put an end to that. Maybe their father's not really incapacitated. Maybe there's no reason to believe that that they're not making these decisions out of love and full understanding of what they're doing, but they want to put an end to that. Or maybe you have a caregiver or someone else who's sort of the one person that the alleged incapacitated person is around all day. They have their ear. They can put ideas in their head, and further isolate people. Studies have shown, especially older individuals who come to depend on other people for all their care, their daily needs, they will put a lot of trust into what they say. And if they tell them that your kids are bad, your relatives are bad, your friends are bad, I'm the only one you can trust. You should put me in charge of everything, or maybe I want to be in charge of everything. These are people with maybe not the they have their own motivations, not the best interests of the person at heart. Maybe you have a relative who's in financial situations and things like that maybe is looking for a way to get control of money, or maybe get control of assets and manage them and earn fees and things of that sort. So those are the kind of people that may make you or your client a victim of really what's a wrongful guardianship, try to weaponize guardianship and use it against you. Maybe they even use it as a threat to get you to do something they want. So what are some signs that you could one day become such a victim? Well, obviously, if you're wealthier, you have assets that can easily be liquidated, you're more likely to be a target. Usually people aren't doing these just for fun or just to try to torture people. They're usually trying to go after money. So if depending on your types of assets, you may be targeted. Now, I don't think, wealthy is obviously a relative term, but when I talk about assets, almost in all the documentaries and the articles and the reports you hear about these cases gone wrong, people had real property, and there were people that were motivated to sell it or put it on the market and have someone else buy it at a favorable price. That can be a big motivator on a lot of these guardianships. And take it for what it is. I reviewed the applications and the people that, not all the applications, but the people who have become approved professional registered guardians in the last couple of years. And I was shocked how many of those people also have real estate, either broker or real estate agent license. And I just don't think that's a coincidence. So think about what kind of assets you have and that there might be a day where someone might want to get control over your assets for their own purposes. And like I said, it might not just be the dollar sign of the total assets. It may be the fact that selling real estate or having control over real estate can be very lucrative. If you have caregivers, family, or other people in your life who are financially strapped, dire financial, circumstances can make people do things that even they probably didn't think they would do. If you have, children, grandchildren, spouses of children or grandchildren who are financially strapped, that may motivate them or color their intentions. And same with the caregivers. So if you have those kind of people in your life, there could come a day where they may let that pressure of those financial situations cause them to do something they shouldn't do in regards to guardianship. When you use unvetted professionals, health, financial, or care professionals, it's a good idea to vet them. Make sure they're people that have worked with other people. They've never had these kind of issues where they've been accused of bad conduct, and make sure that they've never. I would also make sure that have you ever, you're a caregiver, have you ever, been a guardian or attempted to be a guardian over someone and things of that sort. If they have a history of that, that might be a red flag. Anytime you're isolated from loved ones, people you can trust. I use that word loved ones in the meaning of people you can trust. And that's by circumstance, by geography, by whatever, for whatever reason. You are more likely to be, I think, a victim of these because there's not other people looking out for you. If someone shows up one day with a court order or, or court filing and you're being read notice of it, and you have no one else to turn to, that makes you a much easier victim than someone who has kids they can call and say, give me some help. This is wrong. I need you to come to my defense, and things of that sort. Anytime you're on a complete dependence on one individual, I think you're more likely to be a victim as well. It kind of goes along with the isolation. When there's not other people who can speak up and say, I don't know where this person's coming from, but that's outrageous. I see this person on a regular basis. They're fine. They're not up in any, danger to themselves. Their place is usually pretty tidy. They're paying their bills. I don't know where, this is an exaggeration at best of what goes on. When you have other people who can do that, and it's not just you, the alleged incapacitated person, one other individual, that obviously makes it harder for you to be a victim. So if you find yourself in this kind of scenario, you might want to think about that, and depending on how much you want to avoid a guardianship or avoid the temptation for someone to start a guardianship for you, you may want to look into and start thinking about what we're calling guardianship prevention planning. So that's a good segue into section 3. Let's look at some preventive measures and what people do to try to prevent from ever being in a guardianship matter, being the subject of it. And again, to a lot of people, they don't want to be in a position where a court and third parties make the decision as to who will be making the decisions about their lives. So to a lot of people, it's very important to avoid that day where they may be subject to a guardianship. And if you're one of those people, then these preventive measures may be of interest to you. The pre-need guardianship has always been kind of like the go-to. It's the one that everybody, tells their clients. If you have any concerns, then make sure you designate someone you trust. We've already kind of touched on why that can be a problem sometimes, because the person may become unwilling to serve if the situation gets, adversarial enough. May not be in a position to serve at a time, or sometimes the court will just ignore it if they are either one, told, given reason to believe that the designee is not trustworthy, or two, because there sometimes is a preference for a professional guardian in any situation where there's adversarial issues. There's some kind of belief. I've seen this from judges and third parties that a professional guardian will take away all the adversarial issues, because the professional guardian, of course, will only go has no skin in the game, and they will make decisions that are fair and not of their own interest. But we've looked in many of these webinars. That's just a flawed presumption. Professional guardians make money. This is their profession. They have their own interest as well. Now that doesn't mean their own interests are gonna always override things, but to just say that they would never do anything or make any suggestions that would be wrong because they have no skin in the game is just a false premise. Okay, so if you are interested in a pre-need guardianship, and they're pretty easy enough. Section 744.3045 sets forth the what you need to do. Any person who's competent at that time can name a pre-need guardian. They just put it in a written declaration, and there's a form that the Florida Bar puts out. And all you have to do is name the person that you want to serve in the event that you become incapacitated. And like I said, you can even put successors if that person is unable to serve or unwilling to. You got to identify them. Obviously, you know, their name, contact information, and their relationship to you. All of those are really good ways to make sure they're identifiable in case, you know, someone needs to find them one day. And then, of course, you have to sign in. You have to sign in the presence of 2 attesting witnesses, and they have to be present at the same time. You can file the declaration with the clerk of the court, so that the clerk, in theory, when anybody ever files an incapacity petition, they should see this, and that should become part of the court's file. From a practical standpoint, I've seen the clerk's offices in various counties miss this routinely. Makes me wonder if they even look. Also, you can file in a county where you live at that time, but maybe, you know, 10 years down the road when something comes up where there's an incapacity petition, maybe you live in a different county. And so it wouldn't be part of that clerk system. You know, we don't have a statewide uniform system or anything like that. So it's kind of dependent on county to county. Obviously, you'd want the person to have a copy that you've named, you know, maybe loved ones to have a copy, your lawyer, things like that, so that if and when they find out about the proceedings, they can make it known to the court that you've already designated someone. Like it says here, presenting those is supposed to constitute a rebuttable presumption that the pre-need guardian is entitled to serve as guardian. And that courts but they're not bound if they find them to be unqualified to serve as guardian. And it goes beyond just the statutory qualifications. Like I said, I've seen guardian or judges just say, I don't think we need an individual here. I think we should have a professional because there's going to be a lot of fighting, and this presumably will help with that kind of thing. While it's good in theory, it may not actually, you know, if you find yourself in a bad situation, being what you consider a victim of an incapacity petition, and wanting some kind of control over that proceeding, you know, appointing the person, the pre-need guardianship designee may not get appointed. It may not be honored for either because it's not known or because the court finds some other reason not to appoint someone else. You can read on. There's more provisions in the statute about, like, if they refuse to serve, and about how they get confirmed and things of that sort. So here's some more ways that you can have preventive measures. Generally speaking, normal estate planning, financial management of assets, that's been considered a way of minimizing the need for a guardian. People, you know, normal estate planning for most individuals involve preparation of a trust, a pour-over will, a healthcare surrogate designation, and a durable power of attorney. And this type of planning, one is typically trying to reach one of these of these 4 goals, or maybe all of them. They're looking to orderly and timely distribute their assets in accordance with the testator's wishes. And they want to avoid probate. That's why oftentimes you have the trust and the pour-over will. They want to minimize administration costs. Again, that's why you try to avoid probate, and that's why maybe you name people, spouses, other people, or trustees, people that already have knowledge, already have records, and that they would be able to serve in those roles without duplicative measures and costs. And then in some cases, there's tax saving strategy that goes into your estate planning. That hasn't been the case for the last few years because the inheritance tax has been the credit on that has been so high, at least from a federal standpoint, and then not having anything extra from the state. That may change. You know, obviously there's been talk about that changing under the Biden administration, and there's plenty of information out there on that and what people think might happen. And we personally at our firm are seeing a change. People are much more concerned about, you know, tax saving strategies in their estate planning than they were just a few years ago. But generally speaking, those are the 4 things that are in someone's mind when they do an estate plan. And then the financial management of their assets. Usually, you know, they're either managing their own assets, either as their own trustee or they have a professional they use and that they intend to have to use going forward. So that's been our typical estate planning kind of scenario for many years here in Florida. And many people just believe, well, that will handle the guardianship issue. And oftentimes it really doesn't, because as we know, you can prepare a trust for a client until they transfer all their assets to the trust. It really is the trust is of no use. And sometimes people don't do that, or they only transfer some. Um, they, oftentimes will have their income, their steady, or their monthly income, or their the steady income that they depend on. They'll have that separate outside the trust. They may have their home outside the trust. So, rarely do you find the person who has everything, in their trust being managed by a trustee. So one way it may not work is because when the guardianship is filed, the court may find, well, you have assets that's outside the trust, and that the trust may not be completely a complete way to address all your needs. That's just one example. And again, there's nothing here in these usual documents that would give someone or take away an incentive for someone to use a guardianship in an unscrupulous manner to gain control over assets or a person. Even a trust, the court still has, any trust prepared here in Florida where the assets are here in Florida and the trustees here in Florida, the guardianship court will still have some jurisdiction over that trust and the trustee, and obviously whoever they appoint as well may take on the duties that the grantor would have had, meaning that they can replace trustees and things of that sort too. So it may not prevent an unscrupulous person, or it certainly wouldn't take away an incentive for an unscrupulous person to get involved. There is it's sort of I would say a new, and it's certainly a niche area of practice where some firms are doing what I would call very sophisticated guardianship estate planning. It's targeted to try to keep you from ever ending up in a guardianship. It's popular with people who have, maybe step children or step, and second spouses and stuff involved, where there's a lot of infighting, distrust, and things like that. And they have some concerns that one day, there may be someone, trying to make a money grab for the money, and may use, just because they've declined a little bit due to age and things, they may use as an excuse to try to seek a guardianship. So they try to take it completely out of the jurisdiction of a guardianship. And it's really specialized. And like I said, it's pretty sophisticated planning. It usually involves using foreign jurisdictions and things like that to hold assets, to try to circumvent a local judge being able to gain that or give a guardian jurisdiction or control over assets. So it's a little bit more than we can probably get into today, but I just want to let people know it's out there. And again, the goal is to take away the incentive for people to seek these guardianships, because ultimately, even if you do, a local Florida guardianship court probably wouldn't have be able to reach and have ultimate control over the assets because of the way they've been placed and named. I do encourage people, certainly it's not everybody, but people who feel like they could be victims. They have really, really legitimate concerns about this. This is not how they, even whatever the small chances are, they don't want to take the chances of being in this kind of guardianship. They should certainly seek out that kind of sophisticated guardianship estate planning, like I said, where the estate planning is targeted. That's the main goal of the estate plan, and find people who practice in that area and look at some of those alternatives. Sometimes people look at trying to protect their assets by kind of like, let's just transfer them. They suspect they may be a victim of what would kind of term as a weaponized guardianship, a guardianship that's going to be used by someone to try to gain leverage or control for bad purposes. And some people look at a transfer of assets as a step that they can take to protect their assets. Well, I'll just get them out of my name. What's the pros of that? Well, you get the asset out of your name or your sole name, and with the hopes that avoid any future guardian from taking control over that asset. But there's some shortcomings to that. One, you lose title and perhaps your total interest in the property. Now, if you've transferred your home to someone you trust, your children, and you don't think they have a problem with you living there, maybe that's not as important to you. But most people don't like to lose complete title and interest in their property. The court has jurisdiction to reverse transactions if this was done in short, especially if this was done in short time into whenever the guardianship is initiated. The court may decide to reverse that transaction, thinking it's needed to protect, or that it was done, with without capacity, or with under some kind of undue influence or exploitative of umbrella. And then they could find it to be a fraudulent transfer too, and those are always reversible. So the idea that, well, if this ever becomes an issue, I'll just transfer my assets. Well, it might sound good in theory. It might not get you where you want. People use foreign trusts. Their pros is, if done correctly, guardianship courts likely will lose jurisdiction over assets. And what's good about this is it means that they can't appoint a local guardian under their local authority and gain control. And again, if it's done correctly, I suggest you vet the professionals you get to create any kind of foreign trust. You vet them very, very well. Some people say they do them. We see them, but they're not done correctly. And then there's certain ways you can do it where you retain, well, we'll say ultimate control over assets, or maybe foreign trustees, but you still have some control over those assets, and you still at least retain the benefits of the assets. So depending on how they're structured, that can be the case. The biggest con is the cost. There's definitely some significant cost involved. There is some loss of control. Obviously, usually you have a foreign trustee, but they can be used effectively, again, when done correctly. So before we sign off here, I wanted to look at the Free Britney just more because I think it's amazing that you see 20-something-year-olds now seeing words like conservatorship or guardianship because they've become interested in this. And I'm going to try to play just a little clip from a documentary or show that it's on Hulu. The New York Times presents. It's their episode 6, and they kind of delve into this, and it's amazing to see 20-something-year-olds marching and talking about how people should retain rights over their own property and their own person and their own ability to make money and stuff. So I think that's kind of amazing for being in this area of practice, that this is becoming part of our lexicon and part of the kind of the pop culture, these kind of things. So let me play this real quick just so you can get a flavor of what goes on. If you can't see it, you should definitely be able to hear the clip. It's just a little less than 2 minutes.
I'm Adam Streisand. I am a trial lawyer, and my practice is focused on conservatorships and battles over estates.
Hi, Brittany. How you doing, sweetheart? Good to see you.
I got a call from Brittany's family law attorneys and asked me if I would speak to Brittany because, well, the whole world knew that her father was trying to establish a conservatorship over her.
Hey, she's trying to get out. Let her go for a minute.
I met with Brittany.
Hey, be careful.
We agreed to meet at the Beverly Hills Hotel. Well, that's pretty famous because there was a lot of paparazzi. The first question I had was, does Brittany have the capacity to be able to hire me? Does she have the ability to take my advice? So the first thing is, Brittany was able to make the judgment, hey, I get what's going on. I get that I'm not going to be able to resist this conservatorship or avoid this conservatorship, right? So that's a pretty sound judgment. The second thing was, she said, I don't want my father to be the conservator. That was her one request. She wanted a professional, somebody independent.
And was she opposed to her dad as the conservator of the estate, the person, or both?
Both. Brittany did not want her father to be the conservator of her person, right? The person who makes decisions about her medical care and treatment and so on and so forth. She also didn't want him controlling her finances.
So I encourage you to watch that, kind of give yourself an idea of what's going on with the with this scenario, because it actually entertains people and people actually care about it, and maybe they'll care about the situation as it may affect them too. So we're come to the conclusion section, the question and answer. The only question that was posed here online, it's more of a comment. It's just talking about essentially concern about sometimes when medical care providers maybe make wrongful petitions because they're trying to get paid, and maybe they exaggerate things and they're expressing their frustration with that. There certainly has been some stories about that. I don't personally have any experience with it, but it's certainly one of the areas you hear about. Thank you again for joining, and have a great day.